In just a few weeks, the EU starts enforcing a rule that most small business owners have never heard of. If your business uses ChatGPT, Claude, Gemini, or any other AI tool in ways that affect your customers, chatbots, generated images, synthetic voice, you may have new legal disclosure obligations. And many businesses that are affected have no idea they're on the clock. I'm not talking about AI developers or tech companies. I'm talking about the small e-commerce store using AI-generated product images, the agency running an AI chatbot on their client's website, the consultant using synthetic voice and customer-facing videos. If any of that sounds familiar, stay with me because this may apply to you directly. On August 2nd, 2026, Article 50 of the EU AI Act comes into enforcement. This is the transparency obligation section of the law, and it has 3 specific requirements that matter for small businesses. First, if you deploy an AI system designed to interact directly with people, those people must be informed they are talking to an AI. That means customer service chatbots and automated AI assistants on your website need a clear disclosure. There are exceptions, for example, if the AI nature of the interaction is obvious from context. But if you are running a chatbot that customers could reasonably mistake for a human, disclosure is required. Second, if you use AI to generate deepfakes, synthetic images, synthetic audio, or synthetic video in customer-facing content, you must label that content as AI-generated. This is not a blanket rule covering every AI-assisted piece of content. It applies specifically to synthetic media that depicts real or realistic people, events, or statements. Third, generative AI providers like OpenAI, Anthropic, and Google are subject to separate machine-readable marking requirements under Article 50, 2. Most small businesses won't be responsible for implementing those technical markings themselves. However, if you publish AI-generated content publicly, it is worth being aware that these obligations exist at the provider level. Let's be specific because this is where most people either panic unnecessarily or dismiss it entirely. You are likely affected if you run a customer-facing AI chatbot that people could mistake for a human. You are likely affected if you use AI-generated synthetic images, audio, or video in customer communications without labeling them. You may be affected if you use AI-generated voices or imagery in ads or videos targeting EU audiences, depending on the nature of the content and how it is used. A useful rule of thumb: if your customer interacts with it or sees it, check whether disclosure requirements apply to that specific use case. You are probably not affected if you use AI purely for internal tasks, drafting documents, summarizing meetings, internal research, where there is no customer-facing output. And using AI to help write an email or a blog post does not automatically trigger Article 50 disclosure requirements. Here's why this matters even for small businesses. The EU AI Act is enforced at national level. Every EU member state has a designated authority responsible for identifying and penalizing violations. The Act includes significant financial penalties that can reach into the millions of euros, depending on the nature of the violation. EU member states have been building their enforcement frameworks for several years. This is not a law that was rushed in last minute. And the reality is, most of your competitors are not paying attention to this yet. That gives you a narrow window to get ahead of it. So what do you actually do before August 2nd? Step 1. Audit your AI use. Write down every AI tool your business uses. ChatGPT, Claude, Gemini, Midjourney, 11 Labs, whatever applies. Then identify which outputs are customer-facing and which involve direct interaction with customers. Step 2. Add disclosures where they are clearly required. For chatbots that interact with customers, add a clear opening message. You are chatting with an AI assistant. For AI-generated synthetic images, audio, or video and customer-facing content, add an appropriate label. Step 3. Review your privacy policy. Check whether your privacy policy accurately reflects any AI tools that process customer data on your behalf. If you are using AI tools that handle personal data from your customers, Your privacy policy should reflect that. Step 4. Document your approach. If a regulator asks, being able to show that you assessed your AI use and took reasonable steps to comply demonstrates good faith. A simple internal record of your AI tools and what disclosures you have added is enough to start with. The exact requirements depend on how you're using AI, so if you're unsure, consult a qualified legal or data protection professional. August 2nd is weeks away. The businesses that will struggle are the ones that assume this does not apply to them without actually checking. Take 20 minutes this week to go through those 4 steps. It is genuinely that straightforward for most small businesses. If you want to make sure the rest of your privacy setup is solid before enforcement kicks in, your cookie banner, your privacy policy, your tracking setup, I have linked my previous videos below. And if this video helped you understand something that your competitors are still ignoring, subscribe. Every week I break down exactly what privacy laws mean for small businesses. In plain English, no legal jargon, no fluff.